Hi everyone, Jai Hind and welcome to the platform of StudyIQ IAS in English. My name is Bhavar Singh Survey, MXND 115th course in Qualified Civil Services in 2012 and I welcome you on the platform. Now there is the news that I was reading about and this is about the Chief Minister of Maharashtra, Devendra Fadnavis. He have announced that there will be a 7-member committee that will be drafting the UCC recommendations for the Maharashtra. Now over here this is quite important because this news it pertains to the Uniform Civil Code and this committee it will be headed by Justice Ranjana Desai. She is retired Supreme Court judge as well as ex-chair of the 8th Central Pay Commission as well. Now this is quite important because ultimately the 6-month mandate had been given to study the legal as well as the social and the administrative dimensions and submit the report. And the target is that this bill will be tabled in the winter session in Nagpur for the introduction of the bill in both the houses in the State Assembly. And this is quite important because there had been political reactions where there was a split where actually the Shiv Sena welcomed it but the Congress have asked to give the due credit because ultimately the directive principle, that is Article 44, had been included into the constitution by the Congress at that point of time. Now this is quite important because ultimately this raises the question in front of us, and that is that can one law, it can govern the personal life for a nation where we have too many faiths or lots of faiths which actually exist in India. Now we have lots of faiths or lots of you can say the personal laws that exist in India, whether it is for the Hindus, for the Muslims, for the Christians and the Parsis as well, and ultimately that governs the civil law framework, whether it is about the marriage, divorce, inheritance and adoption as well. Now this is quite important because ultimately the UCC it asks whether ultimately the promise of the equality that lies before law, basically which is guaranteed by the right to equality before law and under the Article 14, it could extend into the household, or whether the religious and the cultural rights which had been guaranteed by the Article 25, and we have the right to religious freedom which has been granted by the Constitution. So ultimately that deserves the proper protection precisely where the state it stays out. Now Maharashtra move, it reopens the 75-year-old the constitutional conversation that had happened about the Universal Civil Code that we'll be talking about in this session. So this is one of the important constitutional question that this complete video it pertains to, and we'll be trying to find out the answer about it as well. Now this is quite important, but before moving ahead, let me tell you that when it comes to the platform of StudyIQ, we have the GS Foundation badge, that is Resolution P2I badge, and you can enroll into the badge with using the code BRS Live that will give you the maximum discount onto the platform. Now this is quite important because ultimately when it comes to the Uniform Civil Code, you must understand that this is a single set of the personal law that applies to all citizens, which replaces the religion-based personal laws in the matters of marriage, in the matters of divorce, in the matters of inheritance, adoption and even in the matters of the maintenance as well. Now when it comes to the Uniform Civil Code, it actually includes or covers the marriage, that is the age, the conditions, registration and monogamy. And also it covers the divorce, that is the grounds of the divorce, the procedure and even the alimony, and the succession and inheritance, which is about the rights of the sons and the daughters and the widows as well. And it also governs the adoption and even the guardianship, where there is the uniform eligibility across various communities. But it is very important to note that this does not this does not include any of the religious practices, the worship or the rituals which had been protected by Article 25. It also does not include the personal or the religious identity or the conversion, and also the criminal law which is already governed by the BNS, which actually applies to everyone because we have the uniform criminal governance that is there in the country. It also does not include the property tax, the contracts and the commercial law, which are also already uniform in the country. So this is what Uniform Civil Code it actually means. Now when it comes to the complete the timeline of the Uniform Civil Code, you can see that it was in the 1835 that there was Lex Loci report during the period of the British colonization. And over here the Britishers they recommended the uniformity in the crimes, in the evidence and contracts, but explicitly they have excluded the Hindus and the Muslims personal law from any codification. Now, in 1840, there was a Lex Loci Act that was, that came into existence, and ultimately over here it has formalized the colonial policy of non-interference in the religious matters or the religious personal laws, which have entrenched the separate community law codes for both the Hindus and the Muslims as well. Now, what had happened was that in 1941, when there was the recommendation, so this recommendation came from B.N. Rao, and this B.N. Rao committee recommended that there should be a Hindu code so that there could be the women rights that could be given for inheritance, and there should be the end of the polygamy as well. Now, this was actually opposed at that point of time by the conservative opinion. Now, in 1950, the constitution was adopted. And in the constitution, we have the UCC, or the Uniform Civil Code, which was placed under the Article 44. Basically, the directive principles, they are not justiciable as it is the fundamental rights. And later on, in 1955 to 56, there were the Hindu Acts, or the Hindu Code bills, which were passed, where we have the Hindu Marriage Act, we have the Succession Act, Minority and the Guardianship Act, and the Adoption Act as well. They were codified and ultimately reformed the Hindu law, but it was just the Hindu law that was reformed at this point of time. Now, what happened was later on that there was a Supreme Court case that is, most commonly known by the Shah Bano case, where the Supreme Court granted the maintenance to a Muslim woman under the CRPC 125 that relates to the maintenance. Now, over here, there was political backlash which have led to the passage of the Muslim Women Protection of Rights on Divorce Act 1986, which actually diluted the ruling of the Supreme Court. Now, later on, between the 2016 to 19, there was the Law Commission consultation, where the 22nd Law Commission, it has issued the consultation paper and recommended the piecemeal reform of the personal law over the blanket UCC that should be there for the whole of the country. Now, in 2024, we have seen that the first state to enact and implement the Uniform Civil Code became Uttarakhand. And right now, we are talking about Maharashtra, which has pushed for the committee, and it has formed the committee for the Uniform Civil Codes as well. Now, this is quite important because when it comes to the Constituent Assembly, so there were various debates about the Uniform Civil Code, and here Dr. B.R. Ambedkar, who was the chairman of the drafting committee. So there was the debate that was going on 23rd of November 1948, where he defended the Uniform Civil Code as a goal and not as the compulsion. He noted that India already had the Uniform Civil Criminal Law, and a future parliament that would be there, it could legislate the UCC only with the consent building and not by the force. Over here, he pointed out that the personal law wasn't the wholly settled even within the Hindu practice as well. Now, at the same time, when it comes to this debate, so there was K.M. Munshi, who was member of the Constituent Assembly. He said and argued that UCC, or the Uniform Civil Code, was essential for the national unity and gender justice. Now, over here, he has said the personal laws had kept the Hindu women in a subordinate legal position. A secular state should not privilege the religious codes in the civil matters. Now, there were two more of the debates that actually pertains to the Uniform Civil Code, that is by Meenu Masani and Hansa Mehta. They were also members, and they strongly supported UCC as the central to the women's equality and argued that religious freedom, that is Article 25, it should not extend to the discriminatory civil practices as well. Now, there was the another faction as well that was led by Muhammad Ismail Sahib and B. Paukar Sahib. They were the members of the Muslim League, and they opposed the making of the UCC binding and ultimately argued that the personal law was integral to the religious identity that is under Article 25. And then they said that any UCC or Uniform Civil Code, it must have the community consent and not the top-down imposition. So this is the position that we can see in the Constituent Assembly debates as well. Now, this is quite important that when India became independent, so there was no UCC that was there, and UCC was actually added as the Article 44 under the Directive Principle of State Policy. But later on, Goa was, it was united with India, and it was liberated from the Portuguese. And here it was the first, or you can say the original UCC state that was there in India. Because ultimately there was Portuguese Civil Code that was drafted and enacted in 1867, where there was the colonial inheritance, and basically this was not the post-independence design. So, Goa was actually under the Portuguese rule until 1961, and there was this Portuguese Civil Code of 1867 that I am talking about. So, over here it was already applied uniformly to the Hindus, to the Muslims, and even the Christians that were living over there. Now, there was the retainment of this civil code after the liberation as well, where basically there was the act, the Goa Daman and Diu Administration Act of 1962, which preserved the existing civil law until the Parliament decided otherwise. But actually the Parliament never decided otherwise, and this civil law actually it was implemented in the Goa from that point of time. Now this is where we have the common family law for all communities, where actually it governs the marriages, it governs the divorce and succession regardless of any of the religion. And it is also important that there is community property system where the marital property, it is actually jointly owned by both spouses by default, unless there is any prenuptial contract that specifies otherwise, which is actually quite progressive. But at the same time, this is quite important to note over here that there are certain exceptions where this is actually not a uniform civil code. There is not uniformity in practice, where there are the Hindus in Goa, they can retain the limited polygamy rights under the specific conditions, where we have the codes of usages and customs, and the Catholics, they have a separate church sanctioned marriage process which had been recognized by the state. So although this is the uniform civil code state that we say, but actually this is actually not in practice quietly you can say uniform. Now, there were two of the Law Commission reports over the UCC as well, where the 21st Law Commission that gave the report, that is the reform of the family law consultation paper. It concluded that when it comes to uniform civil code, it is neither necessary nor desirable at this stage right now. Now, this has recommended that there should be reforming discriminatory practices within each of the personal law rather than having a single code or a single uniform civil code. Like, for example, there should be equal inheritance in all the personal laws. There should be ending of the triple talaq type practices as well. And it argued that secularism, it means the equal respect to all religions, not necessarily identical to the civil laws. Now, there was this 22nd Law Commission as well, which has issued the first public notice in 2024, which have invited the views, and it signaled that there is the issue that was reopened rather than settled by the 2018 paper. Now, over here, it received lakhs of responses from the religious communities, the women groups, and the legal experts as well, that actually reflects the political salience of this particular issue. Now, this is quite important that there is no binding recommendation which had been provided by the Law Commission yet. But again, by the 22nd report as well, it was said that there should be, the regional UCCs which have to be implemented by the proper consultation that has to happen, but not a uniform civil code for the whole of country that was recommended. Now, this is quite important because ultimately when it comes to changing or implementing the UCC, so we have to keep this in mind that whether it actually alters the basic structure of the constitution or not. Now, when it comes to the basic structure doctrine that was laid by Keshwanand Bharti case by the Supreme Court of India, and the secularism has been treated as a basic structure of the constitution by the Supreme Court in various of the judgments. Now, this is quite important because ultimately when it comes to the argument where the UCC threatens the basic structure, it is basically about the secularism which has been treated as a basic feature or the basic structure by the S.R. Bommai case in 1994. Now, this is read by the critics as requiring equal respect for the religious personal laws and not any kind of forced uniformity. Even the federalism concerns are there, where we have the personal law which actually is in the concurrent list. It is in the entry 5, and the state legislating the divergent UCCs, where we have Uttarakhand, Maharashtra, they risk a kind of patchwork that undermines the uniform in the UCC itself. And there is also the minority rights which had been provided under Article 29 and 30, which are the basic structure elements. They could be diluted if the UCC isn't carefully drafted. Now, there is also the, when it comes to equality, that is also the part of the basic structure. So, ultimately, equality, which is under the Article 14, it itself is a basic structure element which had been provided by the Indira Gandhi versus Raj Narayan case in 1975. And UCC, it could be framed as fulfilling the right to equality that has been granted by the Constitution and not violating the constitutional ethos or the ethics. There is secularism as well, that is under the Indian model, which is not strict separation of the law or the state from the religion. So we do not have the strict separation as it happens into the Western countries, but this is a principal distance that has been maintained by the state that permits the reform of the religion linked to the civil practices for the equality. And a UCC that had been passed by the competent legislatures through the due constitutional process. It is a vital and a valid exercise, and actually this could not be termed as a structural violation of the constitution. Now, this is quite important that the Supreme Court have laid down time and again that there should be a uniform civil code for India in various of the cases. Now, these are the cases that I'm talking about. There is Muhammad Ahmed Khan versus Shah Bano Begum case in 1985, where the Supreme Court granted the maintenance to the divorced Muslim women under the section 125 of CRPC, and here the then Chief Justice of India, Y.V. Chandrachud, he have urged the Parliament to enact the UCC. However, because of the political backlash, there was Muslim Women Protection of Rights on Divorce Act that was passed in 1986, diluting the proceedings of the Supreme Court. Then there was Sarla Mudgal versus Union of India case in 1995, where it was held that a Hindu husband which is converting to Islam just for marrying for the second marriage without dissolving the first is quite void. Again, over here, the Supreme Court have laid down that there should be the UCC, and then there was another case in Lily Thomas versus Union of India in 2000, where again the matter of the Sarla Mudgal case that was again upheld or reaffirmed by the Supreme Court. Then there was another case, that is John Walamatom versus Union of India case in 2003. Now, over here, the Supreme Court struck down discriminatory restrictions on the Christians' testamentary property rights under 118 of the Indian Succession Act. And over here, again, the Chief Justice of India reiterated that Article 44, it has remained a dead letter. And then there was Shaira Bano case, Shaira Bano versus Union of India case in 2017, where the Supreme Court declared that the instant triple talaq, that is the triple talaq that is there in the Muslim, the talaq-e-biddat, it is unconstitutional, violating the right of the equality that is provided under Article 14, and led to the Muslim Women Protection of Rights on Marriage Act 2019, which actually criminalized it. So these are the various courts or the Supreme Court precedents that you can see when it comes to the Uniform Civil Code. Now, there is the tribal exceptions that had been implanted into the UCC that we see in Uttarakhand. Now, the model of the Uttarakhand is being taken as a model UCC, and over here you can see that there are certain constitutional safeguards which have been provided to the tribal and to the minorities as well. Now, over here we have Article 371 A, C, F and G. They basically protects the customary law and the social practices which are basically in Nagaland, Mizoram and Manipur hill areas, and for Sikkim as well. Now, there is also 5th schedule which actually governs the administration of the scheduled areas, where it empowers the governors to notify or modify and exempt the central and the state laws for the scheduled tribes. There is also 6th schedule which actually provides for the autonomous district councils in Assam, Meghalaya, Tripura and Mizoram, which have the power over the customary law, whether it is the marriage, it is divorce and the social customs as well. And Uttarakhand's UCC that was passed and enacted in 2024, it has explicitly exempted the scheduled tribes under Section 2 and have cited the very exceptions or the protections which had been provided by the Constitution itself. So it is quite important that there had been the tribal exceptions in the Uttarakhand law that had been passed, or it is the first state where the UCC had been enacted in its first place. Now, this will be all in today's session. I hope that there are lots of confusion related to UCC that may have gone away after this session. So that would be all. Thank you very much, guys, for joining me over on the platform of StudyIQ. But let me tell you that we have the course for your GS Foundation, that is Resolution P2I batch, which is available in English only language, and you can enroll into this. And for enrolling this and gaining the maximum discount, you can use the code that is BRS Live, that will fetch you the maximum discount onto the platform. Now, please do remember to leave the like for the video, as well as share this video with your friends who are preparing for the civil services, and even subscribe to our channel if you have not subscribed it yet, so that you do not miss any of the future updates. So that would be all. Thank you. Bye-bye. Take care and Jai Hind.